this edition of Behind the Headlines. Today is Wednesday, the 17th of, is it the 17th really? The 24th of February 2021. And my producer has given me a different script. But welcome to the show, and it's interesting to be back, and to Professor as well, and a number of you others here. Today we are going to be looking at what is most trending, of course, the coming from court. We will not be discussing, I can assure you, I can guarantee you that the persons here will not discuss the merits of what's happening before court, but we will be discussing the events and the implications thereof. What does it really mean going forward for our politics, for our legal system, for the courts? We cannot run away from discussing that accountability, because the courts are also accountable to the taxpayer, to the person listening to us out there. So they must know what the experts and some of these teachers of the law think about what is going on in court, minus going into the real merits. And to discuss all this, I have Anthony Wameli. He is a managing partner at Wameli and Company Advocates. He's one of the lawyers representing the National Unity Platform in this case going on. Anthony, you're most welcome to Behind the Headlines.
Thank you, Jim.
And it must be your first time here.
Sure, it is.
How does it feel?
Good, and I'm comfortable.
You're comfortable?
Yes.
What's going on in court today? You filed an application seeking leave of court to withdraw?
Yes, we did.
Good.
Yes, we did, and according to the law, the same has to be gazetted, I think, by the register of the court. Yeah. After which we'll have deliberations, and then we'll wait for the verdict of the court. Good.
That's Anthony, and next to Anthony, on his left, is another lawyer, Counsel Kalule Ahmed Mukasa. He is a partner with the Crane Chambers Advocates, and he is on the NRM legal team at the Supreme Court. Yes. Mukasa, you're most welcome.
Thank you so much, Charles. I'd just like to clarify that the law firm is called Crane Associated Advocates.
Crane Associated Advocates.
Advocates, yes.
Thanks so much for the correction. Crane Associated Advocates.
Yes.
Yes. And you are versing Anthony, yes, in court. How is it going from your side?
Well, up to until this point in time, we are having a good time.
You're enjoying it?
We're enjoying ourselves. Things seem to be going our way, both on the law and the way the procedure is going.
I thought you were going to say, and the politics.
I don't want to veer into the sphere of politics, but at least on the law and how we are moving, so far we are doing so good.
Good, good. We will be discussing the details later. I will be asking you to what extent you're going to file for costs, and which is an important aspect for a lawyer at this time, but we will be discussing that. Next to Counsel Kalule is Dr. Daniel Roeza. He is a lecturer at Makerere University, and he teaches constitutional law. And Daniel taught me law at Makerere University, so I'm glad that he's here, and I will be firing him the questions while he tries to sensitize and educate everybody out there. Doctor, you're most welcome to this platform.
Thank you for having me. It's always a pleasure to be here to articulate some of these issues and also to interface with co-counsel and yourself. And I look forward to a fruitful discussion.
Forward, I must say, Dr. Daniel was one of the friends of court. Many people came to know in the last petition of the Right Honorable Amama Mbabazi, what was called the amicus curiae, amici in plural. Many people thought that this was a new language and got excited about it, but it literally means friends of court. Daniel was part of that. This time they're not participating. Daniel will be letting us know why not this time. But thanks, Daniel. And finally, on my immediate left, our own Professor Gobi Ramadan, who teaches economics at Makerere University Business School, and he is a panelist on this show. And we will be discussing the same topic and looking at the implications. Let me start with Anthony in bringing us to speed with what has happened so far. So the application for the withdrawal, for seeking leave for withdrawal, has been made. We are now waiting for gazetting and then the ruling. Whatever has happened so far, what do you think is going to be the implication of that on the jurisprudence in Uganda and the politics?
Well, I think, first of all, it is going to be the first of its kind since we started having election petitions on the presidential level. And number two, we are waiting to see, you know, the court has to communicate the reasons for the withdrawal to the Electoral Commission. I'm waiting to see the reasons if the court at all grants the leave. But I think most importantly, it's going to be down on the record that when you sit to make judgments or to listen to petitions or causes before you, the party that is before you or parties before you expect you to show independence, to show impartiality, to administer justice at all stages. And one of the implications of failure to do that is that any of the parties can opt out and get us to where we are now. I think that's very important because at all times people have felt once you go to court, and I think some judicial officers have used this before, that once you're in court, they will treat you the way they want to treat you. Even if you see bias, you have to continue with them until probably come to a verdict. And I think this is now a twist. It's actually a step of courage and boldness of a party to stand up and say, you know what? I will not wait for the verdict. I want to see justice throughout the entire process. And I think that is what we're going to have on the record this time.
Council Mukasa, did you, from the NRM side, did you envisage this? Did you see this coming? Do you think it was wrong for Council, our Malian team, to do this? Or their client to do this?
Well, I can tell you frankly that we saw it coming.
Oh, why?
We saw it coming from the time we received the evidence, and when we replied to this evidence, in our own assessment, we felt that the petitioner had no case left. The petitioner had filed a petition which we felt was weak. And when it came to giving evidence in support of this petition, it was not forthcoming. When the few affidavits that came through reached us on the 14th of February, looked through and answered with more than 200 affidavits, all the three respondents, from a clear assessment, you could see that the petitioner is not having a good time. So we could see that one of these days he might opt out. Not because of the reasons my colleague is giving, and I hope that we will have some time in the course of the show to speak about that, but because the case had crumbled. They spoke about bias at some point, and I believe they've spoken about it in the application for leave to withdraw the matter. But this is a point that they have pressed only in press conferences. See, they have not taken any step to inform the court that we see a point of bias here. All I have heard on that point is the petitioner calling a press conference and telling everybody who care to hear or listen to him that we don't want Judge A, Judge B, Judge C on our case. But that's where he stopped. And I believe my colleague Anthony here knows what else could have been done if they really, really felt that there was an issue of bias that there was an issue of injustice. For you to request a judge to leave a panel hearing your case is not an issue for a press conference. There are steps that you thereby take to get a judge off your case. These steps were not taken. The law is clear. You file an application and get the judge off your case. But if you stop at talking about how a judge is unfair, and you stop at a press conference, my own feeling is that you've not demonstrated seriousness in that allegation. So it could not have been these reasons of bias and injustice that caused us to get where we are now. My own feeling is that my colleague and the petitioner and the entire team should have foreseen that there is no chance here, at least from the volume of evidence we gave them when we replied to the cases.
Okay. How about on the implication to the court? Because that's what now is looks to be the spine or the crux of the matter. That from what, if you read in the newspapers, you watch on television, listen to the radios, then you follow on social media, you get a sense that there are a number of parties, there are a number of groups, there are a number of people, not least the judges, the court, your team, very disappointed and frustrated with what has happened. Why so? What are the implications of this kind of withdrawal? Like he has said, like your colleague has said, that it's the first time.
Well, it is also the first time that somebody has chosen to take this process unseriously. Because in my own view, a presidential election petition, Charles, is a very serious matter.
True. Just like the election itself.
Absolutely. I do not think that it is a contestation that somebody walks into without much serious thought. But I like to believe that that was the case this time around. That somebody went into this litigation without having perhaps probably deeply thought about it and what it required and what they needed to do to push the litigation forward. So I do not think that there is any dent on the court, because none has been demonstrated, at least from the legal circles. All that has been done, as I said, is to speak to the press and everywhere else. But to the court, there is no dent. Nobody has come to the court and demonstrated that it is biased and demonstrated that it is unjust. Absolutely nothing.
Okay.
Yeah.
Good. Anthony, before I bring in before I bring in Dr. Rueza, you hear your colleague saying that you went into the court unserious, you didn't present any evidence credible enough for court to attend to you, to listen to you seriously, and he has in other words said there is no much implication, because he says there is no dent on the court as far as this is concerned. Do you agree?
Of course I don't, and you know that no lawyer will ever say that adverse counsel had sufficient evidence. They will definitely say the evidence wasn't sufficient. But then to 50 affidavits, they will reply with 180 affidavits. But and most importantly, I think this has been the most serious petition of all election petitioners that we have had. You know that he had 15 days to file his petition. 11 were robbed by the first and third respondents by incarcerating him illegally in his home in Magere. And it's on record that they admitted that this is the first kind of a petitioner whose over 1,000 would-be witnesses are either in police cells, prisons, or they are missing persons. Some have been killed. Some of them were recovered. Actually, they were dumped on Saturday when the deadline for filing was on Sunday. And you know that we have been preparing this petition in hiding. Not at home, not in our offices, because it was not possible. Even to deliver the petition at court, we had to use different routes, because we knew that any time probably a drone will come and take either the documents or some of us. So for one to claim that we were not serious, I think it is hitting below the belt, because all due diligence was done. Then number two, if the evidence was not sufficient, how about the 130-something affidavits that are in the court custody, but the court refused to receive the same? I believe counsel has not read those ones. And he also knows that when it comes to election petitions at presidential level, affidavits keep coming in, because we're talking about a whole country. We are talking about people who are being treated as they were giving us evidence. They were on walking sticks. Some were crying throughout the evidence as they told what happened to them, especially the Kalangara group that sometimes drove many of us emotional. So I think this was a very serious petition, and I believe the seriousness that counsel is giving it now is the seriousness that the court ought to have given it from day one. First of all, when we wanted to amend, not to change the course of action, but to increase the grounds for deliberation, so that at the end of the day the matter is deliberated upon and decided completely. Then number two, we came hours late with our evidence, further evidence, and the court, knowing that this is a very serious matter, a public interest matter, decided not to receive the evidence. And now here we are, and everyone is saying this was a very serious case that someone ought to have taken seriously. Then finally, on the petitioner being in the press, you see, for one to recuse themselves from a case, it could be twofold. One, the judge or the justice on his own volition could do that. And probably the petitioner thought that without having to apply for someone to recuse, I will make them know that I think there is bias, in addition to what Mabilis had already indicated, no matter the outcome of what the outcome of the case was. So probably he gave the chance to the justices to think and reflect upon that, and maybe on their own volition pull out of the case. So it's not criminal for him to make a statement as long as he knows and believes that the same is true, and at the end of the day someone can act upon it and save even the time. I wonder if someone says we did not have enough evidence, why they were hunting our witnesses and causing them to disappear, why they captured all our DR forms and held onto them, plus people who are holding. So I think this was a very serious case that was handled very seriously by the petitioner, but was dealt with very lightly by both the court and the respondent. Maybe there is a follow-up question to ask there. Isn't it true that the process of recusal, or asking for it, that it is that judge who is asked to recuse themselves who has to make the judgment? Isn't it true? Yes, it is. And doesn't it go either way? That yes, you can accept to recuse yourself, or you can say, I will stay put. I believe the justifications given are not strong enough for me to recuse. Yes. Isn't it true? It is. So why? I know that I want to be careful here that the person who was making the press conference was the politician who is a client, and not any of you, the lawyers. So I want to be clear about that and be careful about mixing the two. Yes. But why didn't you advise your client that the correct process has been followed, and it is not a must that when you request, it is like advice, someone can take it or leave it? Why didn't you advise your client to appreciate that? First of all, if you look at our application, the main grounds for withdrawal are not the bias or the failure to recuse. Okay. It is the way the court treated our evidence. Oh, okay. Especially the fact that they rejected our evidence, which was just hours late and in the evening. So talk about nighttime lost. That means there was not so much that could have been done by either the respondents or the court from 6 or 7 p.m. in the evening to Monday morning at 7 when the evidence was at court. Okay. And yet the client or the petitioner is telling you that I have difficulty. I am having it so hard. Witnesses are being witch-hunted. They are not safe. Actually, there are some affidavits where we have even failed or declined to mention names of people both in Uganda and abroad. We had experts from Finland who would not fly into Uganda to testify, and they chose to give their evidence knowing that probably the court will allow to hear the evidence, and if there's any cross-examination, it will be via Zoom, because the moment they step into Uganda, they will be rejected, they will be arrested, and the evidence is very crucial to this matter. So even by the time they made the decision to give that evidence, a lot had to be done. So that is the main reason, and the recusal is just one of the, it's a sign that, you see, this is what I'm talking about. This is what bias can do. But it is not one of those primary reasons for which you have pulled out, or you're pulling out. Okay, that's a good clarification. Dr. Rueza, I want you, as an advocate, you are first of all an officer of court. I need us to first inquire into that issue of whether or not, in your view, you think that there is a dent on court, the image of court and the judiciary in terms of the accusations made and whatever is going on, the withdrawal and all that. What is your view on those?
Right. Thanks, Charles. I think we are taking the argument halfway down the road. I think we need to backtrack and ask the question, how did we get here in the first place? Because if you do not deal with the full spectrum of our constitutional and political framework as a nation and how we have reached this point, we'll keep on dealing with symptoms and not dealing with the root cause of the issue. The debate between, you know, the counsel for the petitioner and the respondent is an interesting one, and indeed, it has its place. I personally think that the bigger debate is, was this situation avoidable in the first place? And shouldn't we start asking those tough questions of, why have we reached a point whereby court as an institution is being put in the spotlight, its officers are being put in the spotlight? How did we get here? How did we get to a situation whereby, you know, someone begins to allege that I am not able to access people who should be swearing affidavits for my petition? I think we need to backtrack, and in backtracking, I've argued elsewhere, and I think even with you, that we lost it somewhere when the constitutional organization of our nation was dismantled, when we started making excuses over the years to such a point that we now have a case whereby people have lost trust, and they've lost trust not just in the institution of the judiciary, as Wameli is saying, but in many institutions. And I think that is where our conversation should start. And when I say this respectfully, I know you're the moderator, is to say what went wrong that has brought us to this situation, and how do we correct it? You know, it will be at that point that we can then begin to have a proper understanding. Does the petitioner in the current case have any just cause to even consider questioning the integrity of judicial officers? Of course, we are all bound to this, to the judiciary. We are all, at least the three of us, yourself inclusive, we are all now officers of the judiciary, and ideally we have utmost respect for the Chief Justice and the justices of the Supreme Court, but I would not want us to spend a lot of time with the ping pong, because that is for the court. But now we are in a situation whereby court is being put at the spotlight, and I think we need to start asking questions. Why? Why did we get here? And my answer would be, we are here because of certain deliberate moves that were made before that compromised institutions of the state, that compromised constitutionalism, as at least I understand it, and the rule of law. And that is why we, some of us think we need to have now a bigger conversation. Not just the technical details, but a bigger conversation on how do we rebuild these concepts, how do we rebuild these institutions, how do we rebuild the trust that people have lost. Because Honorable Kyagulanyi is not the first person to make these comments. In 2011, I believe, Dr. Kizza Besigye also refused to go to court. Even though he felt that there was just cause, he decided to use another method. Why is that happening? Is it just that these people are not law-abiding, and is it just that they are bad citizens, or are there certain fundamental issues? And it's those fundamental issues that, Charles, you're talking about, which we tried to bring to the attention of the court in 2016, with the time that we were given as amici curiae, to say, look, court, whereas there are these technical details regarding the elections, I think there are more fundamental issues that as a court you need to address, or call upon the Attorney General to address. And in addressing them, some of the issues that are presently before the Supreme Court will probably not be before it right now. Okay. So for me, I am for a bigger conversation that begins to review what went wrong and how do we correct it.
Okay, which is really for me a very good point at which to come to Mr. Ramadan Gobi. You follow these matters, but I think the benefit that you have is that you are not a lawyer, and so you are not going to go into the technical rigors, but look at it from a bird's eye view of, if you like, a more rational, informed Ugandan looking from above. Do you think that these matters, the kind of disagreements that go on between lawyers like this, dent the image of court, like Dr. Rueza is arguing or proposing? Is there another level at which we need as a country to start having these conversations? And where can it be beginning from, really?
Thank you, Charles, and thank you for the land fellows on the panel today. I'm the only old man out who didn't go to school, according to you guys who always call yourselves land. Number one, I always tell my colleagues, lawyers, my friends, and I have many of them, that they are very lucky human beings. They are the only professionals on earth who are paid for carrying out experiments whose results they already know, or they have. But they still get paid, and paid handsomely. Why do I say so? Because I'm coming from, and it's good that you brought me in at a point where the fellow academic had brought now the conversation to be tricked to the bigger picture. He's asking a very fundamental question. How did we get where we are? And to me, I think actually the entire election, the way we followed it up here, the conversations we've had, they kind of point to that question is asking. Charlse, as you know, throughout the campaigns, actually from nomination to the campaigns to the voting, and we have been having conversations on these issues. Were these elections really organized on the prism of the electoral processes the way they are supposed to be? Were the participants able to take part in this election with the clear conviction that they were engaging in an election where they were able to express themselves and be able to get an outcome out of it? Because look, I sat on this panel severally, and I said throughout the campaigns I was very certain that the issues that should be discussed in an election, in a campaign, I was not hearing them. I was looking at a battle of other issues, of COVID issues, of allegations against, the persons of each other, of those competitors. And like I said one day, there is a difference between law and logic. Law tends to be mostly bending on negative reasoning. How do you argue to undermine the competitor? And I think this is what the lawyers who are involved in this now, they are paid to do. Logic, on the other hand, is mainly positive reasoning. And I would think that the conversation we are having this evening is more bent on that area of positive reasoning, of logic. Logically, is the Supreme Court the problem? If anyone sat in your place where you are watching us, and here we are having a conversation on a disagreement which has led to the petitioner to withdraw his case from the court with that big, allegation on the Supreme Court that it cannot be impartial, and so on. Is the Supreme Court the problem? I don't think so. And I would think that the courts in Uganda have presided over, I'm not a lawyer, but I've seen them presiding over very contentious issues, and they come up with very good verdicts. And sometimes even when those who were, especially in opposition, were always not having confidence in them, there has been this bad, and I wouldn't want to see it continuing really, because we all need to build institutions as we build the politics itself, the democracy. But there are these things which have come in Uganda that judges are cadre judges. And therefore they will not be able to bring out justice. They are likely to favor the incumbent. But these very courts have always, actually when you go and you check the records, you will find very few cases where these judges have ruled in favor of government. They have, because even the government itself, especially the incumbent, the president, has also been severally pointing at courts not to be serious, and so I would think that other than discussing really the legal issues, we need to discuss more the political angle of this conversation. To me, it is the politics, to answer him quickly. The politics of this country has been on a downward trend, to the extent that now there is a group which has emerged of politicians who are saying we came because you guys who are supposed to be in these positions, you have failed us politically, from the legislature to the executive to the local governments and so on. You find now all these offices, they are going to be occupied by people who perhaps in an ideal situation would not have been there. But and even the voters themselves are now engaging in some kind of voting. I don't know how they call it. There is an English word when we were like responding to a situation by saying, let me show them. Is it a protest vote? Or something, you know, bordering that. So to me, all these conversations we're going to have, we shall be engaging in what psychologists call preference qualification. We are trying to misrepresent our genuine beliefs, our genuine views, and the social pressures we have to, you know, to sound politically correct, to sound legally, you know, belonging, and so on. But it's good that the professor from Makerere has brought in that angle. And for me, to end this part of my submission, by the way, I'm very happy that his team pulled out of court early enough, because as an economist who's more interested in the well-being of Ugandans, and I know Ugandans don't eat politics and legal arguments, I would want people to go back to their lives and do business, go back to the farms, because now people were going to be there watching TV every morning as lawyers are arguing on things which...
But you know that that makes Mukasa denied bread.
No. Mukasa is going to be... But what I'm saying what I'm saying is, let us end this wait and see mode in which the country had entered. Perhaps we go back to really doing the things that will build this economy, build the lives of people, because there will be another election in 5 years or 4, and perhaps even the players might not change a lot. So why do we really stop lives for another 2 months? We are there on standstill, you know. Some investors are fearing, let us first wait and see how the court rules. It's good that now most people are saying that this season is over. Let us wait for another round of uncertainty.
Okay, good. I need to bring them back in. The question that is now being raised, Mukasa and Council Mukasa and Council Wameli, the broadening of the discussion and enlarging it to going as far as looking at, you know, what has brought us to this stage. I want you to pick your mind on that, starting with the Council Mukasa. Do you see a sense? I know that you already have made up. You already made up an argument that you don't see any problem coming from court at all, and that's understandable, especially as for an officer of court. But do you think that there are other reasons external to court that have brought us to where it is, especially maybe, i.e., politics, in your view, from your reading?
From my reading of the situation, especially with regard to this particular petition, I do not see any factors beyond the conduct of the petition itself, and perhaps the interest of the petitioner, that you can speak of as having brought us to where we are, I believe, at a point where you're saying the petition is withdrawn. You see,
but the petition is about politics.
But you see,
it's a political disagreement that has brought us there. Isn't that even at a basic?
You see, the Supreme Court has had occasion to handle presidential election petitions. This was the 4th time.
True.
And we've never gotten ourselves in the situation where we are, where a petition is being withdrawn. And the legitimate question to ask there is, what is it that happened in the previous 3 petitions that has not happened now? It is the same Supreme Court to which Dr. Besigye has gone twice, and to which the Honorable Mama went in 2016. We never found ourselves in this situation. So clearly it cannot be the problem of the court. It is the same Supreme Court for the last 20 years that has handled matters of this nature. So
same Supreme Court by name?
Yes, you see, but of course judges come and go.
Yes.
But
the players...
It remains the court.
True.
Now, I believe, in all honesty, that we are here talking about a withdrawal of an election petition because of the way the petitioner chose to handle his petition. 100%. If he had chosen to take this matter with the seriousness it deserved, we would not be here. I do not think that there is anything external or anything beyond that conduct, beyond his intention, that has brought us here. I like to think that the petitioner went into this litigation maybe to test waters, maybe for face saving, maybe for purely political show.
Do you think he went in to try and get justice? Because I was looking at I was looking at Article 126, I think, and okay, exercise of judicial power, Chapter 8, under the judiciary and administration of justice. Exercise under that 126, Clause 1, no, Clause 2D. Says, in adjudicating cases of both a civil and criminal nature, the courts shall, subject to the law, apply the following principles. Reconciliation, that's the one I'm concerned with, between parties shall be promoted. And that is what any litigant, in this case, this petitioner goes to court to seek, isn't it? That we have had a political disagreement, probably what Dr. Rueza and Professor Gobi are talking about, that the players, the contestants in an election, a big election, very polarized, very divisive, disagree and see no one can help them. And then one of them says, let me go to court and perhaps I will get justice from there. Isn't that a basic fact that we all think about?
There are 2 things you've mentioned there, and I believe they are not connected. One is reconciliation, and the other is justice.
Okay.
If the petitioner had seriously walked to the court looking for justice, he would have gotten it. Up to until this point in time, we believe that there was no act of injustice that had been meted out by the court on the petitioner. You see, I have argued elsewhere that the petitioner keeps speaking about justice for himself. But justice is a 2-way traffic. The court is entertaining a contestation between 2 persons, one of whom would like to take the presidency, another would like to keep it. So in as much as the petitioner would like to see justice on their part, is the same way the respondents, each of them, would like to see justice on their part. And I'm glad that my colleague Anthony here said that when he was making the previous submission, that bias on the part of the court is not one of the strongest reasons why they feel they should withdraw from the matter, but rather the way they think their evidence was handled. That points to the point, that points to the question that had they thought, as Anthony said, that they would get justice from the court and bias and injustice is not one of those issues they felt they would get before the Supreme Court, then he would not be here. He would be in the Supreme Court arguing the petition. Because bias was not one of their most serious issues. Their issue was they disallowed an amendment. And we'll get into that. The issue was the way they felt their affidavit evidence had been handled. And we can get into that discussion. You see? So, but what interests me is that they felt, even as their client spoke in the public about injustice and bias of judges, as lawyers, they knew they would get justice. I don't know why they never advised their client accordingly.
Okay. Counsel Wameli, I need you to respond to what your colleague has just said, but also to touch on the following argument of to follow up on the argument of you know, where we got up to this point. Is it political that is bringing us to this point, and can we have a resolution to that respect? I mean, in that respect.
Thank you. First of all, I would like to put the record right. I did not say bias is not one of those things. I said failure to recuse due to bias is not one of our main grounds. In other words, I was saying the petitioner did not apply for the justices or some of them to recuse themselves from the case, but I said the conduct of the court was obvious to him that it is biased, especially when it rejected his evidence the way it did. But I agree with Dr. Ruheza, and Dr. Ruheza, my former house prefect in Soga College, Mwiri, and Professor, that how did we get here? And I'm surprised my colleague, Counsel Kaule, appears to speak like someone who has just come to Uganda, because he thinks it started when we filed our petition. But this particular petitioner is a very interesting petitioner that I even believe the courts would have wanted to listen to, because, especially because of what he went through, not only during campaigns, but from the time he aspired, even before he aspired to be president, but when he became Member of Parliament for Chadondo East constituency. We know what happened in Arua, that even up to today, his cars are still at Arua police station rotting away. We know the guns that were planted on him, and the matter was withdrawn after his driver was shot dead, and no inquest or inquiry has ever been commenced in that particular matter. So you see the build-up from the executive. We know how he wanted to consult the country if he wanted to be president, and we know what happened to his campaign consultation meetings. We paid hotels in Arua, in Zombo, in Gulu, all the receipts are before the court, and how he was not allowed. Then COVID came in and they said, no, it's because of COVID. I said, but even before COVID, this is what he has been suffering. We know that he conducted the entire campaign, or the bigger part of the campaign, with a bulletproof jacket and a ballistic helmet. And all those are issues that were building up. And I think his commitment to the cause did not change when he got to the court. He has been serious from day one. It's only that there is some kind of perception, probably, amongst probably the bench and the respondents, especially his tormentors, the first respondent and the third respondent, that he's not serious. Just like someone was saying here, that probably he's not one of those people that would have been a presidential candidate if the other people had either played their role or had not been beaten into submission by the system of the day. And he has also always said that we waited for the parliament to come to the ghetto. The parliament did not come, so the ghetto got up and got to the parliament. So I think he has been a very serious person. Without singing my own praises, the legal team has been a very serious legal team. We've done our best, but I'm telling you that the way the court conducted itself made us or him realize that it is better to stop at this point than to go all the way, especially that my evidence that I have struggled. You see, it would be different if he picked on anything and just said, I have decided to leave. But this is a person that has 4 volumes of about 50 affidavits each in court custody. and it got there just a few hours past the deadline. And all he was saying is, look, receive my evidence. And actually what happened is, when we got there in the morning on the 15th, if the court had received our evidence and served it on the respondents, then they would have probably raised the issue of being late during the court sitting. But they rejected it. We had to apply for leave. It took us 5 days to fix and hear the application for leave, which was rejected. Okay. And then they are saying they were saving time. So how did we get here?
Can you just hold it there? Yes. I need us, that's a good question at which we can start. And then, Mukasa, I'll bring you in after Councillor Wameli. But that should come after the break. We need to take a quick break. But before we take that break, just know that if you want to follow this discussion, you can follow us on Facebook, UBC TV on Facebook. You can also follow us on via hashtag UBC Behind the Headlines and participate in the discussion. We are also streaming live via YouTube, which is on UBC Television Uganda. That's on YouTube, UBC Television Uganda. But I also want to let you know that if you want to ask a question or make a comment, keep them short, send them via our Twitter handle, but also you can send them to 0772-461-429. If you want to send an SMS message which is a question or comment and you want any of these discussants to respond to, let it be short. You send it to 0772-461-429. I will be reading them when we come back so that we can go into that into those comments as well. But don't make a call, just send a message and we will be responding to them. Let's go for a break, a quick one right now.
Today tastes like a new tradition, like an old favorite. Tastes like all hands on deck and all eyes on the prize. Today tastes like a piece of the action, and it never tasted this good.
Should stop you from finishing what's yours. That's why MTN gives you data bundles that don't expire. Load MTN Freedom bundles using My MTN app and enjoy the freedom to finish your data bundles. MTN.
Your safety while using electricity starts with having a certified technician to wire your premises. Do not use Camille
socket. Chisaka, now that the wiring is complete, how do I get power?
No,
I'll get you power in my own way. And you don't even have to worry about the bills. I'll bring them myself. Is your neighbor there?
She went to work.
Does she have power?
Yes, she has.
If your neighbor has the power, you have the power.
Desist from illegal connections because they are not only dangerous, but could lead to prosecution and death.
Chisaka, what is this? Oh my God, I'm from Umeme.
I did not say Umeme. I am from Umeme.
At Umeme, your safety is our top priority. Report illegal practices to Umeme when you detect them. Download the Umeme app for other services. Stay alert, stay safe, save lives. Umeme, powering Uganda.
The break, and this is behind the headlines, and we are discussing the withdrawal of the presidential election petition by the National Unity Platform, or NOP for that matter, and what does it mean, what that withdrawal means going forward, especially to the courts, to our legal system, to jurisprudence itself, or legal philosophy in this country, but most especially to our politics and all that go with it. Before we went into the break, I had invited Counsel Wameli, who is one of the lawyers for NOP. And Wameli, I need to give you that 1 minute or 2 minutes to wind up on where you were.
Yes, and I was saying, how did we get here? It has been building, the momentum has been coming, and specifically for this particular petitioner. And interestingly, the perpetrators of the illegalities and operations are the first and third respondents mostly. Although the second respondent, the Electoral Commission, also had a very big role in playing down this. And the other factor, that's why we have to look at the withdrawal holistically. It's not just a one thing that came up and said, let me just walk out of this court. The guy has given reasons, but the reasons are almost obvious. You see, in the 4 days that he had, you know, the first 11 days we were preoccupied with his liberty, filing for habeas corpus, moving here and there. Then in the last 4 days we said no. Two things. One, we could have this court exonerate itself. Let's give them a chance. Let's give them the best that we can and let them prove to us that they can deliver justice. But number two, even if they do not, let everyone know what actually happened. So I think we are here because especially the incumbent, the first respondent, has deliberately made competition against him very difficult. It is dangerous to compete against him, especially for that particular first office. And this is why the petitioner is here, and that is why he's acting the way he is.
Okay. Council Mukasa, you had wanted to respond.
Yes, I had wanted to respond to the issue raised by my colleague about how they felt they should get out of the case because of the way the court conducted itself, especially with regard to the application for amendment and with regard to the receipt of the evidence that Councillor Mary keeps talking about. I'm glad he mentions that in petitions of this nature, evidence keeps coming. That begs the question, when this petition was filed on the 1st of February, where was the evidence? What evidence from the 1st of February to the 14th of February, when they were supposed to file their last bits of evidence, how much did they file? From 1st February up to 11th, when the court first sat, there was no evidence. So what does he mean by evidence keeps coming? Where was the evidence?
You want him to respond?
No. He'll respond maybe later.
Hypothetical.
It's a hypothetical question. Because you see, if evidence is supposed to keep coming, if evidence is supposed to keep coming, where was it? On the 11th, when the court first sat to give directions, the lawyer who appeared for the petition on that day said that they had evidence. In fact, on that day, he said he had 50 affidavits to file. and that if he was given another 2-3 days, he would file another 50 affidavits. In fact, he had none. Because when we received this band of affidavits on the 14th, majority of them had been sown the previous day, on the 13th. That was Saturday. So where was the evidence that he said he had before the court? What prevented these people from filing evidence day in, day out, and wait until the court has told them, please have these 14 days. I would sympathize with him for the first 15 days when I supposed to file the petition. But the next 15 days, how much evidence came in? 53 affidavits. You see, a presidential election petition has strict timelines within which it must be heard.
Yes.
It's not a free flow like our normal cases. This petition must be heard and determined within 45 days. And everybody has to work within those limits.
Yeah.
So it cannot be a free fall for the petitioner to keep bringing everything until day 45. It doesn't work like that. Because these things are supposed to be responded to by all the respondents. That is justice. That is fairness. At the point when the court told the petitioner that by the 14th of February, please struggle. We have heard your issues of the first 15 days, but you managed to file a petition. We have given you another 15 days. Please file your evidence. All that came through as 53 affidavits.
Now, there are two things that were raised by Wameli, and I will also ask him about it, whether that is true. One was the aspect of complaint that in the past 3 petitions, 01, 06, and 16, that they were asked, then the petitioners were asked to make oral submissions of evidence. And that this time, the courts were insisting that they should make them written. And that was an anomaly. It looked, no, it was abnormal.
It is not abnormal.
That one. And then two, I think the other thing that they raised was again in Article 126 2E, the common thing that every lawyer is supposed to learn at constitutional law school. That, and I need to refer to it again, that under Article 126 2E, substantive justice shall be administered without undue regard to technicalities. Did the issue of time frame as a condition, did it qualify to be an issue of a technicality, or it was a fundamental issue in this presidential petition that must be followed to the latter?
First of all, it is not an anomaly that the court chooses to take the submissions of the parties in written form. There is nowhere where the law says that, parties should come and argue or make their arguments or submissions orally. It's the court to determine how they want to receive the submissions of the parties. Previously, we've been getting them orally. If this time the Supreme Court felt that they should receive them in written format, that's still fine. Okay? Because, you see, a case is not won 80% on your arguments. A case is won on evidence. Okay? That evidence is what makes a case, not the submission. Submissions are an explanation of the evidence you have given. But 85%, 90% of the cases won on the evidence you've given.
Wasn't that aspect important, what you have just talked about, yes, an explanation of the evidence? Because if you look at Article 104, which is a reference to a presidential petition, it refers to a presidential petition being an inquiry, and that in a case where you have the judges sitting there, the two parties sitting there, petitioners, lawyers, and defendant lawyers, they can then immediately there and then, punch hole or look for clarification into a matter that has been raised.
Two things.
Wouldn't that be important for that?
Two things.
Yeah.
And the court provided for that.
Okay.
In the schedule given by the court, the 25th and I think the 26th of this month was supposed to be for cross-examination. that is the time for inquiry.
Tomorrow and Friday?
Yes, that's time for inquiry, that's time for asking questions with regard to the evidence that each party has brought. 2, there was time provided for in the schedule for all arguments to come and clarify on the written arguments that you have submitted.
So these Wamelis are running away from that?
They are running away from that. So these 2 issues, there are no anomalies. All these were provided for. The court provided, I think, an hour 30 minutes, somewhere, I think, on the 5th, for the parties to come and clarify and highlight the submissions they've given.
That's Wameli. Why are you, the petitioners, running away from that opportunity?
You see, it's very interesting, and thank God you asked that question, because let's bring it in context. In the previous election petitions, the previous 3, 01, 06, and 16, the court had 30 days. But due to the amendment in 2018, the court has 45 days.
True.
And number 2, one of the recommendations, the directives to the Attorney General, third respondent, to do by the court in the previous petition was to amend the law and provide for oral evidence, so that affidavit evidence is one of those options that court can sometimes order. And it is deliberate because a presidential election petition is a public inquiry where the public needs to follow. That's why the court felt that, you see, when you talk about evidence, people need to be at the stand and state what they saw, what they heard, what they know. And when you come to submissions, you see, submissions or oral submissions are the norm. And actually courts have adopted written submissions because it is done in the name of saving time. I believe because the judges are few, the judicial officers are few. But ideally, submissions should be oral so that the people follow. By the time the court makes a finding, they know, because this case, the article you've just read, 126, talks about justice being administered in the name of the people. It is judicial power is derived from that person who is in the courtroom or on TV listening and watching. So for you to hide the evidence in affidavits and then again hide it in written submissions and give 30 minutes for clarification of about 250 pieces of evidence, affidavits, while you respond to about 300 affidavits in reply. Do you really think that is justice? And that is why we thought that this was a deliberate move by the court to make this otherwise public and everyone's case a Chagulani issue that can just be smuggled through and bring a verdict. It is not true that we did not bring in an evidence. When we filed the petition, the petitioner had an affidavit of about 100 paragraphs. He detailed his evidence and it needed to be corroborated. And by 14th, we had 53 affidavits in court. And 130 affidavits were on the doorsteps by 7 p.m. in the evening. And because they were late, we brought them in the morning. So, and if you look at the VSJ case, and especially Mama Mbabazi case, evidence came in even during the hearing. Affidavits kept coming in even during the hearing. But by the time we were given those 3 days as deadline, we hadn't even made our rejoinder. Actually, their president, first respondent, had not served his reply on us. So pleadings were still ongoing. Filing and serving of pleadings was still ongoing. So it is not right for one to say that the 30 minutes are justifiable in any way in a presidential election petition of this magnitude, especially when the public needs to hear. That is why Chagwani tells you that I am taking this case away from the court. I'm bringing it to the people. I will take my time. I will download these affidavits. I will keep giving them to you as and when. I will show you the videos, because the chance I had before the court, I realized I could not have. I will just put my affidavits there. The court will read them probably, and then my lawyer will make submissions of about 30 minutes with so many interjections, and then they will call it a day.
Someone watching us is saying, Charles, the issue of the public, I don't understand it, that taking the court, the case to the public, I don't understand the public. But I needed to bring in Dr. Rueza and Professor Ramazan at this point. Doctor, with reference to the recommendations of the 2016 petition, which went up to the end, unlike this one, do you, what I recall is that the justices emphasized that government, through the Attorney General, must ensure that recommendations are followed and acted upon, and that if they were not, something like some people should go back to, they were given 2 years. I think the Attorney General was given 2 years within which to act. But as we came to this election, there was nothing much that had been done. As a constitutional lawyer, what comes to your mind as this ping pong comes and meets the one of the last 5 years, and what should we do better to make it better for this country?
Well, thank you, Charles. I think it is true that the structural interdict from the 2016 petition required the Attorney General to make certain changes and to report back to the court within 2 years. This was then brought back to the court by an NGO called Kituo cha Katiba, Professor Juko Frederick and Professor Frederick Sempebwa, who wanted the Supreme Court to find the Attorney General in contempt of court for having not been able to do what the court had instructed the Attorney General to do. The court did not find the Attorney General in contempt for its own reasons, but the more important issue is that it gave the Attorney General, I recall, probably about 6 more months. You know, there are certain things that were supposed to be done. For example, do not bring amendments too close to the elections, provide the law for the use of electronic evidence, among other things. Now, I personally would like us to move towards what now do we do? In light of the fact that, yes, the Attorney General was supposed to do certain things, he did some, or that office did some, and probably did not do the rest. We need to face certain brutal facts, all right? The brutal facts that are saying that we have fallen short of respecting the rule of law. We have fallen short of that ideal of constitutionalism that we used to have as a nation, or at least in 1995, when we were passing the 1995 Constitution, and we had that preamble, and the preamble that was saying and acknowledging the past where we came from and trying to address that past. I think now that the petition is out of the court, and it being the second petition that is out of the court. Okay, the first petition that is withdrawn, but in 2011, Dr. Kizza Besigye did not even attempt to go to the court. I think it calls us to go back to the sitting room or to the boardroom or wherever and ask fellow Ugandans once again, what went wrong and how do we begin to address it? We need to start looking for the other power centers that are involved in helping this country to run forward. The church, the traditional leaders, upholding the... You see, this thing is about the citizen of Uganda. How much is the citizen of Uganda involved in his or her own governance? And if we have lost it, as I believe we have, how do we reinstate the primacy of the citizen of Uganda in ensuring that the governance of this nation is for the citizen? Now, Let me give you some brutal facts which I believe are important for our listeners. One, the Constitution is supposed to be a condensed volume of the aspirations, the customs, the aspirations, especially the customs, the way that Ugandans want to be governed. All right? And that is how it is framed. I believe that over the time we have lost out, and I think the citizens need to remember this, that there are certain things in that constitution, and I know the court has deliberated on this and has not agreed with the petitioners previously, that we changed certain fundamentals in that constitution which need to be reinstated. Let me give you an example. The way the constitution was supposed to run, and my friend Dr. Kabumba put this very well earlier on one of your rival stations, and he said that the way the constitution was supposed to be governed, there wasn't an assumption that you would have the incumbent ruling for the period of time that he has been able to rule. Now, do we have anything personal against the incumbent? No. But I do not think that is, and I agree with those who say that that was not the intention of our governance structure. The idea was, for example, one of the complaints that Mr. Wameli's client is saying is that the appointment of the judges at the Supreme Court are made by one and the same person. All right? Now, I cannot blame judges for being appointed in the first place. But if you go back to understand the rationale, the idea was, with term limits, you'd have some kind of change that would enable even the appointment and the swearing in of judges to be before different presidents. You get it? But now you've removed them. You've even removed the age limit. You've begun, you have tinkered with this thing, and therefore you face the same, the very challenges that we have. So we need, and for me, I place this squarely at the feet of our dear leader, President Museveni, that he needs to begin the process of readjusting this social construct, which my colleague Businje was saying is dead, you know, and begin to plan it once again, because you can't ignore certain basic facts, all right? You can't ignore the fact that the majority of voters today and in the next 5 years are young people who do not appreciate what the older generation considers as the sacrifice, the struggle, that the fight in the bush and so on, and the things that the President Museveni did at that time. You know, this is 35 years down the line. Those young people do not appreciate that. Okay? Two, there must be a reflection of their participation in the governance. Now, of course, some people may say that, no, but they are involved in different places, they are being appointed, but no, it has to go beyond just the, you know, the tick box democracy or the tick box appointments, you see. If we do not address some of those issues, I foresee in the next few years to come, I mean, I don't even have to talk about the years to come. I can foresee, look at our voting patterns now, you know, look at how the region of Buganda voted, you know. We can't hide this. You see, the world abhors a vacuum. You know, the world abhors a vacuum. Once a vacuum has been created, today it will be Kyagulanyi, tomorrow it will be Odongotho, or somebody else, right? Who is trying to fill that vacuum that has been created. And therefore, I strongly believe that it is time for us to come back to the drawing board. Bring all these power centers once again. Confront the elephant in the room that we made certain mistakes, and we have made so many concessions at the price of the thing called the Constitution of Uganda and constitutionalism itself.
Okay.
Now, if you do not confront that, Charles, the conversation between my two colleagues here will happen in 2026, will happen in 31, it will continue, but you will not have addressed why it is happening.
Okay. There is a point you started with, that the discussion should be taken to involving other players, and I want to bring Ramadan at that point, because
the other player.
you are the other player, actually, because now we are running away from these lawyers also, and for me, the suspicion I have is what I need to be cured, and that suspicion is a suspicion that the other players outside there, like you, have. I like to, because this discussion is between the courts and politics and the people. Clause 1 of Article 126 says, judicial power is derived from the people and shall be exercised by the courts established under this Constitution in the name of the people and in conformity with law and with the values, norms, and aspirations of the people, like you said. My question with the other people is, if at this point we have situations where political players like Council Wameli's clients and Council Kalule's the clients are failing to agree before a body or a forum which is, which is put in the grand norm, the main law of the country. How then successful shall we be as a country to bring in those other players who are not put anywhere here to start the solution?
No, actually they are there.
In the objectives?
Yeah, they are there.
You know, Charles, this conversation is now getting interesting because there are two things we need to understand. Number one, we are discussing about an issue called power.
Yes.
How to win it,
how to retain
how
it,
to retain it,
how to share it,
and so on and so forth. Power is very interesting. I'm not a student of law or politics.
But law and economics are very similar in power issues.
Of power. There are three sources of power in this world. Number one is legal power, or legal authority.
The one Museveni has.
That one, prescribed in these books, and they give you power. Number two, there is power derived from
cash.
Money. You have access to resources, sometimes not yours, but you are the one to have the authority to distribute them. You are powerful. That's why in this, in any government, after this all the political power, the secretary to the treasury is a very powerful person.
Yes.
In America, there was a man called Hamilton, who was actually, people are saying, was more powerful than the presidents of America, because he had the policy to distribute. The third source of power is relational power. If Odongotho, you are powerful and I've appeared on the same panel with you, in the future, you know, he said that now it is Chagulanyi. Tomorrow there could be Odongotho. If you are the one now to run and become president of Uganda, people will start to give me Very good. No, very good calls, you know, Ramadan. Can you talk to your friend you used to appear with? Relational power.
Yeah.
Now, all those three sets of power, nowhere are they given. They are fought for. They are, you must work so hard to get them. And that's what has happened. Even in very mature democracies, now you see, for example, the election which has been in America, it was like tug of war to get power. So I listen very well to my colleague, your teacher, but he needs to understand that, and this is what constitutional lawyers in Uganda must work on. How do you tweak the incentive mechanism so that you get these people with the power to really get into a conversation on how to share it, but not necessarily even how to leave it. It's not easy to convince them that just leave the power. And the incentives must be practical. In stakeholder analysis, they teach us that. And to, like he has said correctly, President Museveni is a very key stakeholder in whatever conversation you're going to have. How do we involve him in this conversation? Called, some have called it national dialogue, but now I hear he's saying religious leaders, the cultural leaders, traditional leaders, and so on.
And he's saying that when he knows, is it Article 246, that cultural leaders must be apolitical?
The center of gravity of
they must never participate in politics.
Of this power resides in Entebbe. Whatever conversation we need to have has to be looking forward to that. I've seen that we have lost the patience, and as a result, I've started to see us going astray as a country. A lot of ridicule now has come in of those with the power, you know. I see a lot of abuse of leaders who are very powerful people. The Chief Justice, the Speaker of Parliament, they are in this book, they have that legal power I talked about. How do we address them? Now, this is, I think, the frustration which is going to cause us a lot of now problems. And it is because of the way the players also have changed over time. Because as he rightly says, there was a time when those who could hold these kind of conversations were there. And now there are those who are saying, for us it is, there's that word you use these days, rubber-dubber style. We are going to use rubber-dubber style.
Whatever meaning
whatever
it
means, I don't know what it even means.
I think just like that.
Yes.
Whatever
just
style.
like that.
Whatever style, the end justifies the means.
Absolutely. So to me, the conversation we need to have as a country now, going forward, and I said it around that time when they declared results and so on. Number one, how do we redefine the power sharing in Uganda? And this conversation, I think leaders can appreciate it, but not necessarily to tell them that get out of power. Because they have shown you their own also interest, that I am here, I need power, I need still to be around. And then you say, no, you shouldn't. And two, they are very powerful also. They have monopolized violence, they have monopolized the power. And
I'm sorry to interrupt you. You have tickled my mind, and a comparative thought comes to my mind. When President Moi, just in the neighborhood here, had become so powerful, 28 years, I think.
Yeah.
And there were a lot of violence and all these things, and reports of, you know, tortures and all that. You know, is it Nyayo House, which was a symbol of a torture chamber? the political players, especially opposition, engaged, I think, together with even the donors, and started engaging him at a level where they even had to assure him that, you see, our country is most important. You might have made mistakes. As a human being, we all make mistakes. But that there comes a time that one has to leave. And please, we shall not touch you. There will not be any reprimand of you or your people or something like that. And I think it set Kenya on a different path. Do you think, as an analyst and an observer, that that's one of the formulas we should start carrying along? And for even young people like Council Wameli and the team, they should start maybe sensitizing their own followers and followers of people like Chagulanyi, that it is not radicalism or some kind of it, or even threats of prosecuting people that matters, but the country moving forward, and we should start this kind of discussion. Do you think that would work, or it is against,
Charles, one lesson I've learned in development economics is that everywhere is different. And therefore, a solution to one situation might be not applicable to another one. I don't think that can work here.
Why not?
I've told you that actually there could be longevity of the current president, but also there is a history to his getting in power, and also there is a history on how he has held that power over time. And also there is also the motive of holding that power. He has been quite clear so often to those who at least have been listening, not just hearing what he's saying. Is very, very deliberate in his statements and in why he's holding this power. And therefore, I would think that, to me, incentives can only work if they are for sharing power, but not necessarily for handing over power in this case.
Okay.
And because of that, therefore, I know that those who compete, who have been competing with him, I have a feeling that by the time they go to get nominated, because first of all, he's also a very, very hard-working human being, to retain that power. They have been very well knowing that the chances of defeating him in an election, they are very slim. That one, I have a belief that they know. Then after that, I also have a belief that after the election, they have been going to the court, and it's almost all of the times except 2011, but they have also been knowing that the chances of winning the case, they are very slim. Why? Because I'm not a lawyer, but you lawyers tell us that precedents matter a lot in law. And I was still a younger man, but I remember very well those judgments which were made, I think, on substantiality clause or requirement.
Test, yeah.
Yes.
It is in the Presidential Elections Act.
You might come and show a few things which happened, but you must prove that if they didn't happen, you are going to win, or that they substantially changed the course of this result. And I thought that was a fundamental judgment in these arguments you guys were having. You, the lawyers, the land friends.
But the last case of Kenya changed it a bit.
You know, but you see what happened.
They went for the qualitative.
You know what happened in Kenya? And also that is, by the way, also precedent.
Yes.
that the subsequent election was even worse than the other one they cancelled, but they had to go ahead and even the petitioner didn't try to go there. So what I'm saying is, I know that we all know where we came from, we know where we are, and perhaps some know where we are going. The conversation should be, which type of country do we want to build? And after answering that question, who is more likely to be the determinant, the dominant factor, the LCM, as we call it in mathematics?
The lowest common
multiple. And we all know that LCM. And engagement, to me, is the solution than all these arguments we are having.
Okay, good. I know that this is very interesting. For me, I would go for this discussion up to 2 a.m., but time is fast running. Council Alex says, these are questions and comments coming. We might have to, we shall just pick them and then bundle them up, and each person will respond to how they pick it up. And then I will request Gobi to ask all of you, I mean each of you, a question, the culture that we have here. But let me start with the comments. Council Alex says, Council Kalule is speaking sense. Noop lawyers must follow the law, not to put politics into the temple of justice. Then Jeff Walker says, Charles, being a self-styled Supreme Court judge of the Court of Appeal, Court of Public Opinion, I can clearly rule that some of your learned colleagues, including Counsel Mukasa, seated with you in the studio, studied law purposely to oppress the vulnerable, helpless people. This is the code, the other code that Wameli wants.
That Wameli is going to. Wameli's client, not him.
That is Wameli's client.
Hey, not him. I'm sure for him he will not be there.
That it is very unfortunate to see them using their legal career to cover fact and prevent justice. That is Jeff Walker. Thank you, Jeff. Someone called Patrick says, is Noop going to pay costs in case they come up? And then someone called Human Being. The person is called Human Being. He says, thanks, Charles, and your illustrious panelists. Okay, his name is Simpson Mwezi. He says, my name is Simpson Mwezi. My concern with Mr. Chagulanyi and his group is that they are more likely to give excuses than evidence. I'm happy the petitioners have decided not to waste court's time. It is time for Ugandans to be back to work. We have lost a lot of time due to electioneering and the pandemic. The election season should now be behind us. Let's get to work. That is that. And then someone called Patrick Oroni says, Charles, tell those guys that our system has made them lose their professional ethics. Hence, we too have lost faith in them. That is Patrick Oroni. He says, mention my name. And then another one called Davin says, I would like to ask Counsel Wameli, what next for his client, Honorable Chagulanyi? And how about the UN petition? How far have you gone? Or how far are you willing to go? And then another person is called Cake. People have names. Hey, Charles, question to Counsel Wameli. Noop knew it very well that they had that serious evidence they wanted to file to court. Why didn't they file it at once? That's one. Two, Chagulanyi has won several cases in court. Why did he come out saying that court won't serve justice this time? Should we say that when they win cases in court, it is okay, and when court doesn't give justice on their behalf, justice is denied? Another one is called Chris. Chris says, Charles, thanks for the show. Let Counsel Mukasa comment on the CJ's response to Honorable Chagulanyi's so-called press address. Why didn't the Chief Justice respond via press as well, but chose to respond via court, a matter that hadn't been brought in court? Don't you think that alone was enough to scare the petitioner? Another viewer called Samuel says, thanks very much for the show. I'm Samuel Edmonds from Bukoto. Why is it that people power given trust to the hands of foreigners to come and I think this is not for, this is beyond the discussion here. Those are coming, my God, there are 196 messages sent via text. Now that is, thanks a lot. We can't read all of them, but let me just pick just a few. One without a name, Charles, thanks for the show. I'm Daniel from Namaiba. I want to thank Gobi, Dr. and Wameli. The message is not very clear. I'll not read very long messages, please.
Not clear, but not palatable.
Now, another one here says, elections are done. Noop should know that we now have nothing to do and should not waste our time. And then, Charles, my special regards and sincere thanks to Ramadan for analyzing issues professionally. Being my panelist, I need to read this. From Reverend Stephen Chenjojo.
Asante.
Yes, he says Asante. Another person here says, good evening, Charles. The discussion is very important. A lot of Ugandans, unfortunately, including that lawyer Mukasa, are dishonest. The problem of Uganda is not social, economic, religious, but principally economic. The constitution has been changed to favor only some people. Term limits, age limit. We shall solve our problem as Ugandans when term limits and age limits are returned. That is what Fred Tumonjeirwe says. And then someone is complaining and saying, why don't you read my comments? And he says, good evening, thanks for the show. My question goes to Mr. Mukasa. I want him to analyze for me the condition under which the petitioner has been during the election period and how they expected him to obtain evidence. Yet he has been under house arrest. And most of his declaration forms confiscated and office put under guard. Why most of his campaign team are still in detention? Why all this is happening? And you are talking about peaceful election. This person is just complaining. But that's okay, that's okay. We are here for you. And then someone says, Counsel Wameli and the camp, keep it up. One day God will prevail. God always prevails, sir. It is not one day. God is in control. Jimmy says, thank you so much, Charles, for the program. Something you have just mentioned concerning the safety. You have just mentioned something concerning the safety of the president. Those people are even promising him hell. How can he hand over power to them? Even that Counsel Wameli, we are from the same constituency. This is Jimmy.
How is that connected to
I don't know. But There are so many messages. In the end, we cannot read all. Charles, does any member of the panel, save for Dr. Rueza, watch TV and see what's going on in the communities? One day God will help us. That is Victor from Gulu. Members, like I said, time has caught up with us. I will endeavor, and we have not even gone to social media, Facebook and Twitter to get all the responses, but thank you so much. We appreciate. I have only read about 25 of them. There are over 200 messages that have come, and we really appreciate that you are watching. Keep watching, and we will continue bringing you this discussion. I'm going to give each of you two minutes, but you will, you will just compound them together with the questions that Gobi is going to ask each of you. Just ask give each of them the questions so that then they can answer and we wind up and get out of here.
I'll ask the two lawyers who are tussling it out, beginning with I'm glad to meet you personally. I've been seeing you on TV. You're a celebrity these days. Are you willing and also enthusiastic also to continue being the representative of your client even in the Supreme Court of Public Opinion? And what will be the terms of reference? And to the other lawyer, are you going really to ask for costs from a team or a petitioner who has given you your reward on silver platter by not continuing with this?
In law, sometimes we say, who has enriched our jurisprudence?
Absolutely. And perhaps then the teacher of constitutionalism to my good man here who fires me questions every Wednesday. What do you think really beyond what has been said before needs to be done to get Uganda back on the constitutional path needed to deliver us to a country which is fully transformed? Thank you.
Okay. Should I?
Yeah.
Thank you.
Go for it.
I'll begin with professors. Thank you for the question. Am I willing to continue representing Mr. Kyagulanyi? Now, in the court of public opinion, I'm also a judge. Yes, all of us are. You're actually one of the judges in that court. So I don't think there is representation.
But you are a partial judge. You are a biased judge.
So he's also a judge in that court. He's himself. So, but on a more direct note, like we said, this is where people are going to look at the evidence we had gathered. Probably Mr. Kale will appreciate the fact that we had the evidence, but it was just rejected. Should I continue the other questions that came to me? Yeah. Alex said we should follow the law and not politics. I don't know what he means by following the law and not politics, because everything we said in that courtroom is the law, including our application to withdraw the petition, plus the grounds therein. But politics is the cause for us to be in that particular court, because this is a political dispute. So you cannot say that there's a very thin line between the two. But as a lawyer, all we have been doing in the court has been legal and according to the law. Then someone said we have excuses more than evidence. That's not true. We have the evidence. And actually, every Ugandan watching us on this show knows what we are talking about. Only that, legally speaking, you have to translate that into either an affidavit sworn before a commissioner, or a document attached to that affidavit, or a CD, a compact disc, a flash disc in form of video or other form of evidence. So, electronic. We had to do that, and that is why we were saying the court should have allowed us to put that evidence across. Then we have talked about what next for Kyagulanyi. As far as I know, Kyagulanyi is the President General of National Unity Platform. It's a political party duly registered in Uganda. It has 61 members of parliament so far in the forthcoming parliament. So he has a lot of work to do, including transferring that evidence from the court to this court of public opinion. What next? Rather, UN petition. You know, when you file a petition with the UN, they do not respond to you. They have a mechanism, because I've been to that commission's office so many times by virtue of the fact that I'm the leader of the legal team in the National Unity Platform. We've been approaching them from the time we started this thing. So they are very clear. They do not communicate back to them, don't even publish whatever their findings are, but they interface with the government, and actually we could take the matter higher to maybe a special rapporteur of the UN, maybe on extrajudicial killings or other violations of human rights, but still they will not communicate back to you, but they will take it up. Kyagulanyi won several cases. You see, when a court delivers justice, that should not be news. That is the norm. That is the normal. If I win a case and the other party is not concerned about whether there was bias or not, that is a given. That's what is supposed to happen. The anomaly is when there is an injustice, and winning a case is not a bar to my demanding for justice in the next case, and that's what he is doing. Someone commented about the CJ. Actually, Kyagulanyi, my client, was surprised that the CJ has Plan B in his mind, and he thinks Kyagulanyi has it, yet he does not. Kyagulanyi has never mentioned Plan B anywhere. He actually doesn't have Plan B. He says his plan is Plan A, and that is peaceful change of leadership. But the Chief Justice tells him, please begin your Plan B. I know you came here with Plan B. Can you begin on that Plan B? And that's why this person is saying, if the Chief Justice felt that, or whoever feels that Kyagulanyi was wrong to go in the press and make statements, then he should have left them as press statements and not brought them in court. Election is done. Let's move forward. We have a lot to do. Much as the election period is done, but a lot is supposed to be done in the constitutionalism and governance of Uganda. And finally, Jimmy says he comes from my constituency. I hope that is Namisindo County, because it's where I come from. But I think he knows that I have never threatened the president. I don't even have any issue against the president. I've never even met him or even talked to him. And all I believe is that people are only saying we need to do some things right, and there are some things that are wrong, and this is what we are supposed to do. And I think they're doing it in an honest belief that it is a genuine cause and it should take us forward. That's why my client, that's why I am a lawyer to Kyagulanyi. The day he says he is going to use unconstitutional, unlawful, and violent means to try and contest for this power we've been discussing, I think that's the day I will stop being his lawyer. So I think this is not a call for comment, because I have nothing personal against the president. I think that's what I had.
Okay.
And thank you for those questions.
Thanks so much, Councillor Anthony.
Thank you, Charles. I'll also begin with Professor Gobi's question about costs. As a team, we think that we should strongly press for costs. and we will do so. And the reason is to deter this kind of conduct from petitioners that we think is rather than serious. Like I said earlier, we believe that a presidential contestation is a very serious matter. So you do not want to see in future people walking to the Supreme Court as a matter of show, as a matter of drama, as a matter of political fun. We think that by the time somebody goes to argue a presidential election petition, they've clearly thought about it. They know the vagaries of the process. So it should not be a matter that should be treated lousily. That's why we think that it should be deterred by a heavy sentence for costs. On the issue of the CJ, for me, I think that, first of all, it is wrong for anybody to go going about in press conferences, attacking judges whom you were before. And if the Chief Justice had the occasion to speak about this conduct and guide the parties and advise them, there's nowhere else he could have done it apart from the court, because that's his only platform. He could also not have held a press conference and rebutted everything that the petitioner was talking about. The only platform for the Chief Justice is the court. And when you come before him, he has the occasion then to advise you and guide you, and that's what he did. On following the law, when my colleague said that when they came to the Supreme Court, all they've done is to follow the law, I think that's being unfair to himself, because they have gotten to this point because they have refused to follow the law. They've refused to follow the orders of court. They have misconducted themselves. Court tells you, please file this by this time, you refuse. And this misconduct started way back from the campaigns, and it has been thrown into the Supreme Court at the end of it, or the end of the day. During the conduct of the campaigns, the petitioner was an unruly person. Okay, there were guidelines, there were laws to be followed and everything, and he refused across the country to follow no law. Okay, there were guidelines. I would tell you, for example, that in many places where he was to hold these meetings, the campaign meetings, his agents would agree with security the day before that this is the venue you're going to use. They agree with his own agents, and some of these agents were serious people, members of parliament. And when he would turn up at the place agreed where he would hold his campaign, he would just refuse. Say, I'm not going to hold the campaign, they'll hold it there. So that misconduct right from the campaigns is what we think that he has brought to the step of the Supreme Court, and that's not acceptable. On how he would have gathered his evidence when he was under detention, I spoke earlier here that I would sympathize him for the first 10 days. But he was given time to recover from those 10 days. From the time when he filed the petition on the 1st of February to the 14th of February, he had massive time, 15 days, 15 out of the 45, to go and look for evidence. He failed. He failed to file it. So the issue of him being under detention, it was covered, okay, when opportunity was given to him to get this evidence, but still failed to do so. Lastly, on the issue of constitutional amendments, and how they have disorganized us and everything, I think that these amendments do not come from anywhere else but from the people elected by those who are complaining. These amendments take place in Parliament. These amendments are done by people who are selected by the population. So if anybody is complaining about how the Constitution has been amended several times and introduced this and that, I don't think me or you or anybody else is if there's anyone to blame for any constitutional amendments that any person doesn't like, it is the elected leaders. And that's democracy. People come and are elected by the people, and they feel that the Constitution needs to be amended to meet the aspirations of the people. That's what will happen. Thank you.
Okay, finally, Professor Dr. Daniel, but you kindly add this because someone called Emmanuel said, "Good evening, Charles. Help me ask the gentleman in a black coat." Then I scanned around and saw it was Dr. Rweza. Does absence of term limits mean there is no constitutionalism in Uganda? Thank you.
No, actually the quick answer to that is no, that is not, that's not what it means. But that's just an example of the nipping away of our understanding of constitutionalism. Like I said, the law doesn't operate in a vacuum. There are other concerns that we need to look at. You see, the petition before the Supreme Court is just one aspect of justice, that is procedural justice, and that has to come out clearly for us. You have restorative justice, you have reconciliation, you have distributive justice. Those are all issues. Distributive is economics, really, that need to be addressed. And so that small nip of term limits, bring it, take it away, and so on, has a fundamental effect it plays on the whole constitutional underpinning of our nation. To answer Professor Gorova's question, there are many things that we can do. And first of all is to remind the citizen that they have important parts that they can play in this whole debate. But even as we remind the citizen, we have to also remind the leadership of our nation that in the next 50, 100 years, what do we want to see for our nation? You know, what do we want to see? And one of the ways to begin preparing for what we want to see is to begin addressing some of the concerns that I personally am seeing. There's an increase in virulent language, you know. At the same time, there's a lot of gun slapping, there's a lot of kidnapping that is taking place, or at least alleged to have taken place. There is something that is going wrong, and the leadership should be able to confront those issues. You know, you cannot excuse them away. In South Africa, they did the Truth and Reconciliation Committee or Commission, and they said, okay, what went wrong? Can we address it? In some spaces, they even asked for forgiveness. You see, they dealt with both inter and intra-tribal conflicts, you know. The ANC also had its own issues. There were killings within the ANC that they had to deal with, you see. So those cannot be. Healing is inevitable if we are to move forward. Healing is inevitable, and we must have that space. I mean, you've seen, you know, we all know what happened in northern Uganda, and why it is important to confront those issues that led to the kind of violence and conflict in northern Uganda, and even up to today. You know, the majority of the interventions from government have been mainly procedural justice, you know, the punitive, retributive justice. We still have to address the other issues that come with truth-telling, healing, memorialization, among other things. You know, they are very important. And so therefore, court is but one form of finding the truth. And if Wameli's client has pulled out, it does not mean that we should just. I wouldn't want us to take the approach of Mr. Kalule of saying these guys are not serious and so on. No, these are our fellow lawyers. You know, I believe Honorable Segona is Honorable Segona, Mr. Wameli. These are serious lawyers. Let's not rubbish them. But let's sit down with them and say, okay, fine, this thing has gone away. It's maybe not gone the way we have wanted. Now, what do we do?
In any case, maybe that's a very important point for lawyering. In any case, the lawyers are supposed to act on the instructions of their client. They don't put themselves there. Yes. Yes. So that alone is a basic from which we can begin.
I believe so. And
they're supposed to act on the instructions of their client.
Yes. Yes, of course, I cannot change Mr. Kalure's view of whether he thinks they are serious or not. But professionally, it is to say you've represented someone. You know, when Mandela came out of jail, after having served 26 years, or more, he had a conversation with the prosecutor who sent him to jail and said, I know what you are doing, you are just doing your professional job, all right? But now we must heal this nation. We must heal this nation. And whether he decides to ask for costs and as a way of deterring, that's another conversation. But I think even when you do not believe, one of the ways to peace and reconciliation is to try and stand in the feet of the other party. And even when you don't agree with them, try and find out, do they have any just cause? Do they have any point? Can I try and understand where you're coming from and your viewpoint? You know? And that goes beyond and outside the ambit of procedural justice, you know. That, Professor Golobi, is the way I think we can begin the healing process. Sorry, Gobi. The only way we can begin the healing process, you know. Otherwise, we shall remain in our camps and think that that it is all good now. No, let's think 50 years from now, 100 years from now. You know, Charles, from your studies in law, you know, your studies in journalism, how certain conflicts seemed to have been okay, but they were actually in negative peace, not positive peace. It was negative peace, and at the earliest form, at the earliest ticking point, it blew up. You know, you no longer have USSR. Why? Why don't you have USSR? It's because there are certain underlying things that were never addressed that led to the balkanization of that region. So for me, I am very passionate about you know, confronting this elephant and preparing for generations. I'll close with this, Charles. You know, I've been teaching constitutional history and constitutional law. In my teaching, I realized that one of the gray areas in our history and our constitutional process is that northern Uganda was problematic. The conflict had been there almost since 1986, you see? And that is how I started doing the research that led me to eventually end up in international criminal law and transitional justice. You know, otherwise, if you hear the stories of the young men, you know, who felt that they had been punished for what their parents had done, and they were waiting for an opportunity for them to do likewise to people from the south, I think it is important for us to think through. You know, when you go to the street, the other day I was on one of your rival television stations, and I made a comment, and someone wrote on social media and said, of course, this is Ruhweza. What do you expect? You know, and even when I do not belong to a specific, or I'm not a card-holding member of a specific political party, the fact that I am Ruhweza gave me a certain stereotype, you know. So we must address those issues. Yeah. Let us not think right now we are safe, but what about tomorrow? That's why for me I'm very concerned about bridging the gap and healing the wounds. Then we can talk about a new constitutional dispensation.
Thank you so much. Once a teacher, always one, and I appreciate your time, Dr. Rweza. Thank you so much, Council Kalule, and for a good job that you're doing, and and together with the Council Wameli, I want to appreciate you so much. I know you have been busy. The day has been a very hectic one, going through this application for seeking for leave to withdraw, and for both sides, I know for now it is cracking, yeah, you know, now it is cracking the heads and reading and researching and all that. So for you to, both of you and Dr. Rweza as well, to find time and come to the show this late hour, we really appreciate here at UBC and as behind the headlines. And certainly Mr. Gobi, who is always here every Wednesday, thank you so much, and we appreciate you as well for your sacrifice. To the rest of the team, from the team here, the technical team, the producers, all of them, we want to appreciate you. But most especially, I always say that you who is the viewer who sits out there in your sitting room to listen to this program, let me not forget, there is this lady I met in the bank today, and we were both masked, and then she said, you look like, you sound like, I was talking to the, you know, the tellers and the officers of the bank, so she said, you sound like the gentleman I listen to and I watch a lot on TV. Thank you so much for the program that you keep doing. I celebrate such people, and they humble me. They make the show, you know, more valuable to do, because it means people listen. It means that you appreciate the little that we do to contribute to, you know, the dialogue, the talking, the conversation that goes on. And like they said, that once you stop talking, then violence begins from there. So let's keep talking here on platforms like this. And even when Kyagulanyi withdraws finally, we shall call Wameli and Kalule back to now discuss and go into the merits now. From this court first, not the public one. And we shall ask the public to join us here. Thank you so much. This is Behind the Headlines. Keep it here at UBC. And bye-bye. God bless you all.
Weekend on UBC.
Hey. As YouTube's popularity continues to grow, the content creators, people that upload stuff on it, their reputation also grows with it. I have a very beautiful and charming lady with a brains as well, the host of our very own show, which also runs on YouTube, called A Chat with Methia.
Hello everyone, it's your girl Methia Lydia. Welcome to my YouTube channel, and this is my first video. I hope you enjoy your stay here as you have a chat with Methia. I've always wanted to do a show like sitting down with someone and profiling people, talking about their lives, discussing issues, something of a sort. Though I presented my ideas to different TV stations and they all rejected.
Time. They say we shall get back to you.
They tell you we're going to think about it, but they never really do. They don't get back to you. Some of them just reject you and they're like, no, we can't do that. So I was like...
have you faced any rejections?
Yes, on TV. Like, you take your proposals, and because I've always wanted TV, like from day one, I've always wanted TV. Yeah. Believe in what you do. No matter how many people are there to compete with you, just believe you're the best.